Is he still here?
I think so.
Yeah, if some. And we can count Heather is here. Okay, for real this time. I call to order the Verona Committee of the Whole / Common Council meeting for January 28th at 8:19 p.m. Sorry again for being late. We'll begin with the roll.
Mayor Diaz.
Here.
Alderperson Cronin.
Present.
Alderperson Gaskell. Here. Alderperson Journey.
Here.
Alderperson Kemp.
Here.
Alderperson Cole.
Here.
Alderperson Posey.
Here.
Alderperson Touche.
Present.
Alderperson Riki is
In the building.
in the building.
Excellent. Next up, we will have public comment. If anyone from the public wishes to speak. Seeing no one from the public rushing up to the mic, we will move on to item 4, which is the approval of the minutes from the November 12th, 2018 Committee of the Whole meeting. Questions, comments, motions?
Recommend that the minutes from the November 12th Committee of the Whole meeting be approved.
Motion by Alder Journey, seconded by Alder Cole. Last chance for corrections to the minutes. Seeing none, all those in favor of approving the minutes from the November 12th, 2018 Committee of the Whole meeting, say aye.
Aye.
Opposed, no. And they are approved. With that, I will turn it over for a presentation regarding Wisconsin Open Meeting Law by Claire Silverman and Maria Davis, the Legal Counsel and Assistant Legal Counsel of the League of Wisconsin Municipalities. Thank you for being here.
Thank you for inviting us. It's our pleasure. This law is such an important law. It's really one of my favorite topics to talk about. It applies to all municipalities regardless of size, urban, rural, big, small, and it's just a very important law. And that is because when you are acting as governing body members or members of a governmental body, you are acting on behalf of the public. And so it's very important that the public have the ability to see what you're doing, to see you in operation, so that they know what you're doing and they can hold you accountable. And so we have a very clear legislative statement of policy under the open meeting law. And it says, in recognition of the fact that a representative government of our type is dependent on an informed electorate, it's the policy of the state that the public's entitled to the fullest and most complete information regarding the affairs of government as is compatible with the conduct of governmental business. So it's not absolute access. It is limited because it's as is compatible with the conduct of governmental business, but it's a very strong presumption in favor of openness. The law says that it shall be liberally construed to achieve its purpose. So I think when you are looking at the law and thinking about whether something needs to be noticed or needs to be in open session, it's always very important to come back to the policy and let that inform your decision. And what it means when it says the law will be liberally construed to achieve its purposes is that when in doubt, the courts are going to err in favor of openness. And so that is what governmental bodies should do as well. What the law requires is that all meetings of governmental bodies be preceded by public notice, publicly held in places that are reasonably accessible to the public and open to all citizens at all times, unless otherwise expressly provided by law. It seems simple enough, but you'll see the words in red: meetings, governmental bodies. Those are terms of art, and that means that those are defined by statute. And I would say 95% of the questions we get have to do with whether something's a meeting and whether something is a governmental body. And it's not as simple as you would think. So it's important to look at the definition, and it matters less what a body is called. A governmental body is defined as a local agency, board, commission, committee, council, department. It goes on and on. Or a formally constituted subunit. And importantly, that's created by constitution, statute, ordinance, rule, or order. And it's specifically, the definition of governmental body excludes a body or subunit formed for or meeting for the purpose of collective bargaining. There was recently a case in which the Wisconsin Supreme Court dealt with what was a governmental body. It was a school board, and the staff was reviewing curriculum. And so normally when you have staff meeting, it's not subject to the open meeting law because they're staff carrying out duties. But the court said that if you have staff meeting and it's a defined membership and collective responsibilities are vested in the body that's distinct from the individual members, then that is a governing body. So loosely organized ad hoc gatherings of government employees without more do not constitute governmental bodies. So if the mayor were to meet with all department heads, for example, that would not be considered a governmental body. But if you give them a specific responsibility, duty, and they have a defined membership, then that would be considered a governmental body. And a meeting is convening of members for the purpose of exercising the responsibilities vested in the body. And we'll talk a little bit about convening of members because you don't have to all be physically present. You can convene in other matters. But the term meeting specifically excludes social or chance encounters which are not intended to avoid the law. Supreme Court of Wisconsin has set forth a two-part test to determine if the open meeting law is triggered. The first is that there has to be a purpose to engage in government business. Engaging in government business doesn't necessarily mean you're making decisions or discussing things. It can satisfy the purpose prong if you are just merely information gathering. So that's important to understand that the purpose is broadly construed. There's a rebuttable presumption that arises. If 1/2 or more of the members are present, then the meeting is going to be rebuttably presumed to be for the purpose of exercising responsibilities. And that's important because that means that without more, it will be considered to satisfy the purpose prong. So if half of the members of a body are at the local tavern together, it's going to be presumed that it's for the purpose of exercising the responsibilities. But once you explain that you're simply gathered there to watch the Packer game and you're not conducting any business or talking about governmental business, then you're good because that's social. And so that's excluded from the definition of meeting. Second prong is the number. The number of members has to be sufficient to determine the body's course of action, and that can be the affirmative power to pass a proposal or the negative power to defeat it. And the numbers can be tricky sometimes because you don't necessarily need to have a quorum to violate the law. You can have negative quorums, and that is the power to defeat a proposal. And that's a gathering of less than 1/2 the members of the body if the number of members is sufficient to defeat a particular action. You can also have walk-in quorums, and this is a little bit, I think this poses a bigger problem. This is a series of gatherings among separate groups, always less than a quorum, but the members agree either tacitly or explicitly to act uniformly in a sufficient number to reach a quorum. As I mentioned before, you don't have to convene all together in the same place to have a sufficient number of members. You want to avoid, what I call watering hole meetings, and that's where you convene at the local coffee shop or the tavern after a meeting. If you convene electronically, that could be a problem. That could be email or instant messaging or use of social media. And if you're communicating without physically gathering, then the question the court will ask is, to what extent do your communications resemble a conversation? Does it seem like you're you're having a conversation. They'll look at the number of participants, the number of communications, the time frame for the communications, and whether it seems like a conversation. You know, if you receive a letter, that's not a problem. You know, you receive it and you take it in, but you're not conducting business back and forth. That's not a problem. So Department of Justice has recommended that local governments not use electronic communications because once you hit send, it's out of your control. You don't know who's going to reply. That's really not a realistic, I think in this day and age, thought that, you know, governments aren't going to use electronic communications, but you should use them with caution. And some members have a, you know, don't reply to this. This is a one-way communication on the bottom. But it's very important to be aware of that when you're engaging in emailing and electronic communication. So it's important to know about the statutes governing the quorum for a common council, because you have to know what your numbers are and what they could be. So for a council with more than 5 members like yours, 2/3 of the body is a quorum. The mayor is not counted for purposes of quorum. And in the absence of a particular vote requirement, a majority of a quorum is sufficient to adopt any ordinance or resolution. The problem comes sometimes when you have a statute that requires an extraordinary vote. For example, if you're going to amend your budget, that requires a 2/3 vote. So on an 8-member council, that means 6 has to vote in favor of amending the budget, and 3 could be a negative quorum. So if those 3 got together and decided that they were going to oppose the budget amendment, and they discussed it and agreed that, then that would be a negative quorum. The numbers can also be difficult because you don't know exactly who's going to show up at a meeting, right? You might have some members absent. And so, for example, with an 8-member council, if 2 members announce that they're going to be absent at the next meeting, so you'll have 6 in attendance. Vote of 4 would be required to pass a measure. So if 2 of the 4 convene and agree that they're going to vote no on something at that meeting, that could constitute a negative quorum for that specific meeting. Case law is not clear about, you know, whether if you have to have a crystal ball. I don't think you have to know, you know, who's going to be at every meeting and how the votes are going to play out. But I do think you just need to be very careful because the number can be less than a quorum. If you have a quorum, or actually half, of a body attending a meeting at another body to gather information or otherwise engage in governmental business, then the courts have said that separate notice is required. And that's why very often on, you know, even on today's agenda or tonight's agenda, it said that members of a quorum or a quorum of members of a body might be present at this meeting, because you need to let the public know, because if that's where the governmental body is getting its information, it has more importance to the public. And so it's important to let the public be aware that there will be a quorum of the body at the meeting of the second body. So, and frequently this happens with community organization meetings. You know, you're all very civic minded, and so you are concerned with what's going on in your municipality. So you might be in attendance at a meeting that's not a governmental body, but if there's enough of you there, it's important to make sure that the public receives notice. I'm going to turn it over to Maria to discuss the notice under the open meeting law.
So as Claire mentioned, all meetings must be noticed, and there are 3 main things to think about when considering how to meet the public notice requirements. You want to think about timing of the notice, content, and specificity of the notice. For timing, statutes require at least 24 hours notice prior to the meeting. And when you're calculating the 24 hours, you exclude Sundays and legal holidays, but you do include Saturdays. There are cases where a municipality may be able to provide less than 24 hours notice, but only if it's able to show good cause that it's either impractical or impossible to provide 24 hours notice in that situation. Good cause isn't defined, but it's likely akin to an emergency situation, and inconvenience alone isn't a sufficient reason. Notice also needs to contain certain information. It must identify the body that's meeting, the date, time, and location of the meeting, and describe the meeting's subject matter. And any contemplated closed session must be identified on the notice agenda as well. For specificity, that largely comes into play when you're identifying and describing agenda items, including any contemplated closed sessions. To properly notice, agenda items must be presented in such form that's reasonably likely to apprise the public. And what that really boils down to is the public's right to be given the best notice possible at the time that the notice is being prepared. The required level of specificity depends on certain factors. First being what, if any, burden there is for providing more detailed notice, the public's likely interest in the subject matter, and the public's ability to anticipate the subject matter. For that, the more novel or non-routine the subject matter is, the greater the burden to be more specific in your notice. So for example, if there is an agenda item labeled discuss road improvements on West Verona Avenue, if the planned improvement is to patch potholes, that notice might be specific enough, but if the project is to put in 2 large roundabouts, that's something the public might have, pretty significant interest in, and you're gonna probably wanna be a little bit more specific to put them on notice that there's something that might draw their attention to the meeting in particular. After notice is created, the presiding officer, in the case of a city, that's the mayor, or the presiding officer's designee, communicates the notice to the public and to the media. The general manner in which you communicate notice to the public is by posting in 3 public places where it's likely to be seen. I think Verona posts in City Hall, Miller's, and the library, which are all good locations. One thing municipalities might want to think about is whether any of their posting locations offer 24-hour access. Notice to the media includes the official newspaper if one's been designated, and any media that have filed written requests for such notices. And any other statutory notice requirements must be followed as well. For example, publishing a Class 2 notice for a hearing on any proposed zoning amendment. Meetings always begin in open session, and like Claire said, they must be reasonably accessible to the public and open to all citizens at all times unless the statutes authorize an exception. Preferably, they should be held in a public place. Places such as the private dining room in a restaurant or a private club are not considered reasonably accessible. Like Claire said, total accessibility isn't required. It just must be reasonable. So if a governmental body is expecting a high level of public interest in a particular meeting or agenda item, and in turn expecting a pretty large turnout, you're going to want to make sure that the meeting location reflects that in terms of its capacity. And of course, ADA accessibility is also required. In general, individuals are permitted to record or tape an open meeting. Governmental bodies must make a reasonable effort to accommodate those wishing to do so, as long as it's not interfering with the meeting. And additionally, citizens do have a right to attend and observe open meetings, but not necessarily to participate. So a public comment period isn't required, but it can be provided if it's authorized and on the agenda. And on that point, municipalities can impose time limits and limit the discussion to subject matters on the agenda during that public comment period if they wish to do so. Governmental bodies should not be using secret ballots to vote, with one exception, that is to elect the body's own officers. So for example, the Common Council president, or police and fire commission's president, VP, secretary. But otherwise, records must be kept of all motions, roll call votes, etc. And it's important to note that other laws may also prescribe more particular requirements as well. Closed sessions are a limited exception to open meeting requirements. The purpose is to serve the public interest. It's not to offer comfort or convenience for the governmental body, And likewise, closed sessions are not intended to be used simply to avoid controversial matters. They are permitted when authorized by the statutes, but they're never required. The governmental body does have discretion whether or not to utilize an authorized closed session. There are two types of closed sessions, contemplated and spontaneous. Any contemplated closed session, that is one that's planned prior to the meeting, it must be noticed, and notice should identify the subject matter of the closed session, the statutory exemption that applies, and any intent to reconvene in open session. Notice for closed session must still be as specific as possible, and simply reciting the statutory exemption is not considered sufficient for specificity purposes. Spontaneous closed sessions are permitted without notice so long as an exemption still applies and the subject matter has been noticed on the agenda. It's important to note, though, that once that closed session is completed, governmental bodies cannot reconvene back in open session for at least 12 hours. So if the need for a closed session does arise during a meeting, you might want to think about finishing all your other business on the agenda prior and having that closed session come at the end of the meeting so you don't run into issues with the 12-hour rule. Yes? Where it's been used?
I think that only comes into play when you go into a closed session that was not on the agenda and that didn't. I don't, because we only know what people bring to us. Sure.
So there's a certain process to follow when going into closed session. The presiding officer should announce the desire to move into closed session and then cite the authorizing exemption. A motion should be made and seconded, and that motion is going to pass on a majority vote. Votes regarding whether to go into closed session must be recorded unless it's a unanimous vote, and that can actually offer some protection for a body member if they voted against a closed session that turned out to not be authorized. It's also important to be very careful while in closed session to stay on topic and not let the conversation stray into an area that's not covered under the exemption, and that's going to be true for contemplated and spontaneous closed sessions. So getting into the exemptions, there are 11 exemptions allowing for closed session. We're not going to go into all of them, but we will focus on the handful of them that are most commonly encountered by governmental bodies. And again, it's important to note that they're strictly construed by the courts, so if there's doubts about whether a closed session is permitted, it's probably best to avoid it and remain in open session. The first exemption covers deliberations regarding a case that was the subject of a judicial or quasi-judicial trial or hearing before that governmental body. And case contemplates a controversy between or among adverse parties and proceedings designed to enforce rights or remedy wrongs. So this wouldn't include, excuse me, this wouldn't include a discussion regarding whether to grant a simple permit, but deliberations regarding whether to revoke a liquor license might fall under that exemption. Bodies that consider appeals, such as zoning appeal boards, may not convene in closed session under this exemption, and likewise the meeting of municipal boards of review regarding property tax assessment appeals must also be conducted in open session. Another exemption allows closed session to when you're considering the dismissal, demotion, discipline, or licensing of any public employee or person licensed by a board or commission, or the investigation of charges against such person and the taking of formal action on any such matter. A public employee or official must be given actual notice of any evidentiary hearing that may be held and of a meeting during which final action might be taken regarding the discipline or demotion, etc. In the closed session, correct. If there's no evidentiary hearing or if the final action is going to be taken in open session rather than closed, then no notice to the employee is required. You can also use closed session when you're considering employment, promotion, compensation, and performance evaluations of any public employee that the governmental body has jurisdiction over or exercises responsibility for. And this has been interpreted to include discussion and selection of candidates during the hiring process. Note, though, that it only applies when a specific employee or person is being considered, not when you're talking about a position in general. So, for example, if you are setting a salary range for a particular position, that's not an appropriate use of the exemption. But if you're talking about whether or not to give a raise to an individual in that position, that would be. If you're considering financial, medical, social, or personal histories, or disciplinary data, or preliminary personnel problems, or investigation of charges against a specific person, you may also use closed session, but that's only going to be permissible if discussing such consideration in public would be likely to have a substantial adverse effect on the reputation of any person that's discussed therein or another person that's involved. And here, it's not enough that a person might be embarrassed or would prefer confidentiality. There has to be that likelihood of a substantial adverse effect on their reputation. Closed sessions may also be appropriate when competitive or bargaining reasons require. For example, deliberating to establish the authorized purchase price for a parcel and then also deciding what your initial offer price is going to be. But the closed session has to be required, meaning that the governmental body has no option other than to hold a closed session to protect those interests. And two, it's important to note that it has to be the municipality's competitive bargaining interests, not, for example, a developer that may be involved in negotiating the deal. Lastly, closed session may be used when a governmental body is conferring with legal counsel, but here the attorney has to be actually rendering legal advice, and that advice has to be regarding litigation that the body is currently involved in or likely to become involved in. So for attendance and voting in closed session, in general, a governmental body can determine who may attend a closed session. However, appointed and elected body members can't be excluded from a closed session of their own body. And if a governmental body is a subunit of a parent body, the subunit has to allow the parent body members to attend unless the parent body's rules have established otherwise. It's a little different potentially with independent statutory boards and commissions, such as library boards or plan commissions. Those aren't considered to be a subunit of village boards and common council. So in the league's opinion, we think that they may properly exclude members of a village board or common council from their closed session, so long as those board or council members aren't a member of, say, the library board or the plan commission. When it comes to closed sessions for items which the governmental body plans to take action on, voting should be done in open session unless the vote's an integral part of the reason for the closed session. Stated differently, voting needs to be done in open session unless it would compromise the need for the closed session. Any member participating in a closed session vote can require that the vote's taken in a manner that records everyone's individual vote, but all motions and roll call votes of closed sessions must be recorded and preserved, and they're going to be open to public inspection to the extent that public record law allows. Typically, once the reason for going into closed session has expired, it's going to be unlikely that there's adequate justification for not making the records of those proceedings open to the public.
And, let me say that any member can require that the vote be taken in such a manner that vote of each member is ascertained and recorded applies generally to all votes taken during a governmental body's meeting. So not just a closed session.
When it comes to open law or open meeting law enforcement, violations of open meeting law requirements are enforced by the district attorney for the appropriate county or by the attorney general if the DA doesn't pursue. If neither take action, the individual who is bringing the complaint can bring an action on behalf of the state. For a governmental body member to be culpable under a violation, they have to have knowingly attended a meeting where a violation of the law was taking place, and they may be subject to forfeitures, and those forfeitures can range from $25 to $300 for a violation.
And that's personal liability, so that's not subject to reimbursement by the city. So, and something that's not in your handout, but which I should mention, is if there's a violation of the open meeting law, the action taken is not necessarily void, but it's voidable by the court if the court determines that the public interest in enforcing the open meeting law is greater than the interest in enforcing the action taken by the governmental body. There is a really terrific resource that's available free as a PDF on the Department of Justice's website. It's the Department of Justice's Open Meeting Compliance Guide, and it was updated in March 2018. It includes links to all the cases that decide the various points, the statutes. It's really an excellent resource. And so you have a link in your materials, and I encourage you to read through that in your spare time when you're not at a meeting. So if you have any questions, we would be happy to take them.
Before I open up to questions from other people, I want to ask a question. Back on the slide about electronic communications, is there any chance that the Department of Justice would ever actually release more realistic recommendations? Because I don't understand how the city would do business if we actually, and I've never heard of any other municipality in the area who follows these recommendations. Is there any chance that they would loosen up a little bit, be realistic?
I think they know that governments are using it, and I would be shocked to learn that the state does not use any electronic communications, because I know they do. I just think they're saying, they're just cautioning and saying, look, we think that it's you have to use caution, and you can get in trouble. So it would be nice if they would come out with a more realistic recommendation, but I'm not aware of them doing that.
Okay, thank you. Questions from the council? Or, Alderiki?
I have another one related to that. If you blind carbon copy all the recipients, then if they do reply all, does it electronically not go to anyone but the sender anyway?
Right.
Is that correct? So, like,
I can answer that, being in the field.
there be good.
Yes, you're correct. If you blind CC everyone, when anyone of the recipients reply, it only goes to the sender. So you don't, in my understanding, is that is not a meeting, therefore it is not a subject of the violation.
Okay, and that's probably true. That's a good way to proceed. But then if the sender is receiving input from various people who are applying under the blind CC, then that person might have enough information to carry forward in a way that would be like the conduct of business. So I just think you have to be careful even then, but that would be a good practice.
The other thing I want to add is the notice of to encourage people not to reply should actually be at the top of the message, not the bottom, because we're all human and we don't always read the entire message sometimes, get to the part we want, and I think that's one of the more important pieces to point out.
Good suggestion.
And when it comes to what Claire mentioned about replying to the sender when you've blind CC'd, one example we've heard of municipalities using is if there's some information that you want to get out to your other council members, sending something, having the clerk disseminate the information and blind copy everybody. That way it helps reduce the risk of that return correspondence starting to become like a conversation.
Alan, are you ready for more emails?
You betcha. Sorry.
Other questions? Alder Journey?
So if you went to a commission meeting as a citizen, and during the public comment part, could you take part in that public comment, or would you not? So if I went to a commission meeting and they would have the public comment session, would I be allowed to get up and make a comment?
That's a good question. I would say probably yes, if you're making, I think the answer is yes. When it's public comment session before like the Common Council, then the Attorney General's office has said it's inappropriate because you have access to the agenda, and so using it in that fashion would circumvent the open meeting law. But I don't think you're intended to not be able to communicate with your boards and commissions, but because you're on the governing body, I think you do need to be mindful and be careful and be commenting really more as a citizen approaching that body than as an alderperson.
Yeah.
My understanding for the Plan Commission meetings is we notify, there's a notice that there could be a quorum of the council there because sometimes there is a quorum of the council there. So that's, we're covered on that. Alder Gaskell?
Just following up with that. So I have stepped down from here to make public comment so I can speak as a resident of Verona rather than an alder. So is that, I mean, I think that's something that several people have done in the past as alders, is to hop down during public comment. And public comment, we have it before every single, agenda. So it's sort of a free-for-all. If you have anything you want to say at all, doesn't necessarily have anything to do with the agenda. If you want to come yell at us about anything, you can, right? So we should not be doing that, is what I'm hearing.
The Attorney General's office has said no, because they said you have, I'm not saying that there could never be an exception. Let's say that, for example, your road is being assessed and you're subject to that assessment. You could probably speak as a member of the public, but there's an Attorney General letter that says you should not be using that public comment period to circumvent the open meeting law. So you have to be really, I would say, very selective. I would recommend against it, but if you feel it's important to address the council, I guess you take that chance. But
To clarify, does it, if the topic is on the agenda later, would that make it okay to comment? Or is it just for anything? Because there would be public notice that the council was going to talk about it.
right, I mean, one of the things about the public comment period is that it's really the only time when you can have somebody come forward and bring something that's not on the agenda. So I don't think it would be appropriate for you as a council person to come and approach, to jump down for the public comment session for something that is not on the agenda, because you could have placed it on the agenda. But
I
if
think
it's on the agenda,
when it was done, when I did it,
people will
it
know
was
about it.
in response to a comment that was made publicly that I just wanted to personally address, I guess. Instead of sitting up here as a member of this body, it was more correction getting on the public record, I guess. So I don't know if that's something then that we should just do from up here, but I'm not unclear on what public comment means, if it's literally just comment or if we have the opportunity to address the comment as the body.
I would be careful, very careful about replying to your public by coming down and addressing the council as a member of the Common Council. I think that's problematic. But, because you have access to the agenda, if you wanted to say something about a topic or deal with it, you could direct it procedurally or ask that it be put on for another time. But I don't think it's appropriate for you to use the public comment period to respond to comments that are made.
If I'm recalling right, that topic was on the agenda or something related to it. Alder Journey?
Question. So are walking and, was it negative quorums to be avoided?
Yes. I mean, a walking quorum is something more than just, enough members in the right place. There is that component of the tacit agreement, the explicit agreement that you will act in such a way that, of course, that would violate the open meeting law. That's definitely to be avoided. The negative quorum, you need to be careful. If it's inadvertent, if you didn't know that 2 members weren't going to attend, I don't think district attorney would probably focus their efforts on prosecuting something like that. But yes, those are technically violations of the open meeting law. If you have, the purpose to engage in governmental business and you're doing it in sufficient numbers, that triggers all the requirements of the open meeting law. So those would be violations.
Other questions from the council? Alder Touche?
I think this falls under walking quorum, and I just want to verify. I've run into a number of situations my tenure here where I've had developers want to meet with me, and part of their invitation they'll say is, I've met with so many other members already. For me, it's an alarm, and I just tell me if I'm right or wrong, please. That I once I hear that, I tend to take a pause and say, I think it's better to have our meetings, during public comment or during their item, because I feel like it's probably reached a point where enough members have been met with by the developer that I've had them tell me, well, I've gotten the support from X, Y, and Z person, and you're the last one I got to talk to. And I'm like, then you probably have what you need. So is that technically a walking quorum, or is it really something I shouldn't be afraid of and have a meeting with this person? Because it's definitely happened to me more than once, and I tend to ask that they can share all their thoughts and ideas why their project is so great to the council.
I think the better response is to have the developer present their concerns and issues at the meeting, because the whole purpose behind the open meeting law is that the public gets to hear the business being conducted. And so what you really don't want to happen is that, it's a done deal and come in and there's just approval and nobody knows why it was approved, or it's voted down, nobody knows why. So it's best to have the discussion in public. That being said, I don't think, it's sort of like the use of electronic communications. I mean, it's unrealistic to think that developers aren't going to approach members and talk. And you could have a policy where you say, I'm sorry, I just don't do this. I want to have the discussion at a public meeting. But I think the important thing is that the developer's not acting as a conduit to bring information from one member to another. So that's really the concern, is that the members are getting the information. But I think for there to be a violation for the governing body members, they'd have to be, using the developer as a conduit to pass information along. So best practice is to have the discussion in front of the public.
Thank you.
Other questions? Alder Ricky?
I just had one more about the public comment section. I couldn't find it in the packet again, but when you were talking about the, I don't know if it's just the mayor or the governing body has the ability to limit time that public comment can be made. Can they do that in the moment if they see there's a large number of people that are all going to want to, or does that have to be noticed on the agenda beforehand?
I believe it needs to be noticed on the agenda, but I'll defer to Claire on that one.
I think the body can have procedural rules, and I think it's better to have them at the outset. I think it could be for a particular meeting if you had a large number of people. You could ask people not to repeat what other people have said. But I think really the important thing is to have the rules set forth beforehand so that everybody feels that they're treated fairly. So, if somebody, if you don't have a time limit and all of a sudden you're limiting a particular person, it might be thought that maybe you're limiting them because of their viewpoint. The rules should be accessible to all so that there's a feeling that it's fair.
I guess I just want to say I don't really like to limit people's time, because we traditionally haven't done that. I think it's been done once or twice. But on the other hand, you have a room full of 70 people, and if everyone talks for 10 minutes, we're never going to get out of here. And then some other people might not get a chance to speak because someone talked for half an hour. So you want to at least that's how I look at it. I want to balance. I want people to say what they want to say, but also not take all the time so no one else can talk. Alder Touche?
To your point, I agree with what you're saying. When I was on CARPC, we would see rooms and people out in the hallway to where we did have a rule of a 3 minutes per person. It was a little tough when people would offer their 3 minutes to someone else who's still speaking. It felt like an abuse of the system, but other than that, I agree with Luke in general. I mean, when there's a reasonable number of people and time constraints, I think it's a great practice.
Other questions from the council? Seeing none, thank you so much for being here.
Our pleasure. Thank you for having us.
Thank you. With that, we are on to item 6. A motion to adjourn would be in order. Motion by Alder Touche, seconded by Alder Ricky. All those in favor of adjournment, say aye.
Aye.
Opposed, no, and we are adjourned. Thank you.